Welcome to a Stepping Stones to Awareness show. This is show part 2 of the British Constitution. And I'm Caroline Stevens, and today in the studios I've got John Hurst and Fraser Rees. We're going to ask the question, whatever happened to the British Constitution? John has been a policeman for 30 years, and now he's left the force, he can speak freely. So John, over to you. Whatever happened to the British Constitution?
Well, what I'm going to tell you is a story of deceit and betrayal by the establishment in order to protect themselves.
Who do you call the establishment?
Anybody in a position of power, really. In order to oppress people, a good way to do it is convince them that they're not being oppressed. And oppression, is best described as tyranny. Tyranny is rule without law. And I'm going to argue over the next 10 minutes that we're subject to a tyranny, which is a rule without law, and they've got away with it because we didn't know about it. So first I'll talk about what happened to the educational system in relation to this topic. Then I'll talk about the education of lawyers, and then I'll talk about some efforts that have been made to recover this information. And by the end of it, you'll understand that we do have a constitution, and where you can find it, and what use of it is to you. So,
okay.
So the first issue is anybody educated since the late 1970s, whatever their topic, including law, will not know much about this topic. There used to be O levels and A levels in the British Constitution, and it's perfectly normal. And our grandparents would have had a working knowledge of it. In the late 1970s, probably as a result of joining the European Union, any mention of the Constitution in the formal education system was abolished. Because it was abolished, the other side was able to get away with breaching it.
So did Ofsted exist then, or was that just the civil service?
Well, the previous system is different schools could sign up to different education boards. There'll be Oxford, Cambridge, London, and so on. And parents didn't have a uniform national curriculum. They could choose which syllabus, which education board they wanted to. Some were more religious than others, and parents would have a choice. Not very large, 5 or 6, but certainly.
Wouldn't it be up to the school, though?
The school would choose which syllabus they'd work to, and then parents could choose the school.
Is this why we've got such a big issue with this Brexit, John? Because I guess it was, again, against the Constitution to join the EU, and if we weren't taught about it, then I guess that's how we've just...
The only way title to the kingdom should change hands is by trial by battle, and whichever side wins, God's on their side. That's the common law rule. What was done, jurisdiction was changed by sleight of hand, and the other side have progressively tried to impose their legal standards on us. Our common law system is based on the presumption of innocence, where the Crown has to prove you've done something wrong, and the continental system based on the Napoleonic Code, everyone's guilty until they can talk their way out of it.
So this is a problem in France. Okay, thank you for your clarification. Hence we're supporting.
Yeah.
Okay.
So anyone educated since the 1970s in school won't know about it. If you want to be a lawyer, the first qualification you need is a law degree.
I thought you were going to say to lie.
Well, yes.
The ability to lie.
Yeah. Well, yes, yeah. I think anybody who looks at it objectively will be forced to accept that a university these days is a political indoctrination centre, and part of the problem.
Ability to teach.
They're not, the subjects they're taught are specially chosen, and political activism is considered normal, and neutrality is a thing of the past.
Could you clarify that? You're talking to somebody who's a qualified teacher, so I'm just intrigued.
Well, once the national curriculum comes in and there's a uniform national syllabus,
you have to enact. You basically got to carry out exactly what the prescription is.
Yes, that's right. Yes, that's my understanding. My late wife Tina, she's a junior level in a school, but a teaching assistant. She said that if it's the third Thursday of the term, we'll be teaching this particular topic every year, regardless.
That's right.
Could be. And she felt constrained by it because she remembered the previous system. She's a similar age group to me, the national curriculum came in the 90s, wasn't it? Mid 90s, something like that. And it's allowed government to impose thought control.
Right, and they can rewrite history as well.
Rewrite history, the
Put
memory
a different emphasis on the way subjects.
That's right, and the teachers don't know any better. Obviously, you're a mature lady, and you remember the previous system. I understand you went to a grammar school, did you?
I did go to grammar school.
Yeah, me too.
Sorry, John. This just makes me think: is this the same kind of problem we have with the police at the minute and the CPS? Is it sort of
those who control the recruiting, the training, control what happens, the outcome, don't they?
Right,
and that appears to be what's happened.
The last 30 or 40 years.
If you say to the typical educated person, "Have we got a constitution?" they will think about it. If you say, "Have we got a Bill of Rights?" what are they likely to say? It's American, weren't they?
Yeah, it does have more of an American connotation.
Okay,
but we started here, though.
It started here. Yeah,
we are the birthplace of common law.
Common law, and the Americans are in fact emigres that kept the common law better than we did.
So no sales tax in Delaware, first state.
Well, that's one issue.
Well, they've kept the faith longer than we have.
Well, true. So cut a long story short, if you want to know what the British Constitution is, you have to consult history books. Fortunately, as a policeman, I had access to the Commissioner's Law Library in a building called Wellington House, around the corner from Scotland Yard. In my own time, but I was allowed to use it, and I discovered a lot of material that had been hidden and suppressed, and I remembered it because I've got a good memory, and I'm now positioned to report. In the late 1980s, around about 1988. 1997, a situation arose whereby a whole group of people in the country, about 20,000, were about to be dispossessed of one of their common law rights. And what I'm referring to is what's known as the Dunblane incident, where a man with a gun held on certificate goes into a school and shoots several people and then kills himself. There was an immediate
outcry, wasn't there?
Immediate outcry.
Yeah.
And people that held guns on certificate for years were suddenly dispossessed of them. This generated a certain amount of resistance. And
didn't it affect the Olympic team as well?
It did, yes. Yeah,
what happened with them?
They can only train abroad. They can't train here. So we haven't run.
So they could train in France, couldn't they?
Yes, yeah.
But not here.
Well, on the subject of the right to bear arms, if you go to YouTube and look at my video, John Hurst with the RKBA, Right to Keep and Bear Arms, I'll give an account of this. Now, the interesting thing is that the legislation relating to firearms, it doesn't infringe our Bill of Rights. It doesn't take away the right to bear arms. It's purely Home Office policy. Since the 1920s, the Home Office have had a policy of not wanting the public to be armed in case we revolt, in case we go communist. That was a threat in the 1920s. Russia had turned communist. And that policy is maintained to the present day. It was challenged last year by a man called Graham Moore, unsuccessfully due to lack of funds mainly. So as far as the Constitution is concerned, you have to ask yourself what sort of regime you want to live in. Democracy is a term that's used about the United Kingdom, isn't it? But a democracy is where a majority, say 52%, are able to impose their will on the other 48. And do you feel safe living in such a situation?
Ooh.
Yeah, you don't. So on the other hand, what we are and what we should maintain is a constitutional monarchy where the sovereign has certain things they can't do. In our case, there are 13 articles in our Bill of Rights which are prohibitions. For example, the king can't impose cruel and unusual punishments. The king or queen must arrange jury trial. Any taxes raised must be for the specific purpose and not kept any longer than necessary, and so on. There are 13 articles.
But you said
us. Sorry.
You said about the 52% and the 48%, which you are referring to the Brexit.
Yes, that's right. Yeah.
But then we were taken in without.
I take your point. What you're saying is it fair for we the 52 to impose it on the 48? That's a different case because joining the EU was unlawful because we've given away sovereignty. The Queen gets the job on authority of Parliament and the common law, and she can't give it away to somebody else because it's Parliament decides who should be. So the history of what happened in 1992 is this. Mr. Heath was the Prime Minister, as you know, very dubious character. And for those who want to research it, if you look into the allegations against Mr. Heath, they're quite horrific. It appears he was an agent of a foreign power, Germany. He was subject to blackmail by them. And the common law rule about a contract or a treaty is that both sides have to disclose fully what's going on. And if one side has been subverted, then that contract is obtained by fraud and it's void. So we're not really in the EU because
it's fraudulent contract in essence.
That's the way
so why are we going through this pantomime in the mainstream media?
Well, you've had Mr. Shrimpton in this chair, haven't you? And he did a speaking tour around the south of England about 20 years ago, and I went to it, and it was part of my waking up process. Fair play to him. It is a pantomime. And in actual fact, the Miller case in the Supreme Court is quite an important thing.
The Gina Miller case of 2017.
That's right. Now, if you were to fire up your browser and look for the Supreme Court Miller case, what you'll find is, if you go to paragraph 44, it will say, ever since the Bill of Rights 1689, the Crown has had no power to suspend the law.
The Crown has had no power to suspend the law.
The law. And what that refers to is that if you're going to have a king who's got divine right to do what he wants,
or queen,
that means they can say, I'll ignore that law. So Henry VIII could cut people's heads off, for example.
Which is why you've got the 13 protectory for the people, as it were, from a tyrannical reign for example, Henry VIII.
So what happened in 1688? We have a revolution. The revolution is a fight. There was a battle at Reading. About 100 people were killed, mainly the baddies, King James II supporters. He wanted to turn the country Catholic. The population objected. They fought him to a standstill. He fled to France. As he fled, he chucked the Great Seal of England into the River Thames.
He chucked what into
the Great Seal of England? His badge of office.
Right.
In the old
What's that then?
Well, in the old days, kings didn't need to write because they had people to do that for them. There was far too grand. But they had a seal.
But could they read what people had written for them?
They probably could, but
because you could write any old thing, couldn't you?
Well, the Great Seal of England was like a person was the king. It was supposed to be the guarantee. If you look at old charters, you'll find a large wax circle being stamped with a seal.
Is that where you get the signet ring from?
And signet ring was a small example. So as far as the Constitution is concerned, if you want to research it, have you heard of the American Declaration of Independence?
Yes.
Well, it's kept in a elaborate museum. Is that
in Pennsylvania?
My understanding is it's in Washington, and it's a device like the TARDIS. Do you remember the TARDIS from Doctor Who? There's a circular glass display case with this thing in, and because it's so valuable, it lowers below the ground and doors seal overnight.
Oh, yes.
That's right. It's a precious and revered object, and school children are taken to read it. Now, our equivalent is of the Declaration of Rights was obtained after the Battle of Reading and after James II had fled, and his daughter stood to come onto the throne. And in order to stop her becoming tyrannical, a new revolutionary settlement, a new agreement was required, and that was recorded in the Declaration of Rights. What happened was...
and when was the Battle of Reading?
1688.
Right, which is when
just before, earlier in the year. So, you have to bear in mind at that period the current calendar that we have didn't apply. The year changed in March, in actual fact. So 1688 began in March. 1687.
Okay.
Turnover, and it's the origin of the financial year. The financial year is April, but the reason is that there's slight variation in different years. We have a fight. We have a fair fight. 100 people are killed. James II surrenders by fleeing to France, and the population get together, and they can't form a parliament because a parliament is the Lords and the Commons and the King or Queen to give her all assent. King's done a bunk to France. What should we do? Our shrewd ancestors knew that the final parliament, James II, had been stuffed with what we now call cronies, placemen.
A bit like the House of Lords today.
Yeah, exactly. Yes, that's right. Yes, nothing changes.
History repeats itself.
Indeed. So what they did was they went back a stage and they called the previous parliament. There were 4-year parliaments then. They called the members of the previous one before it all went horribly wrong. Those who are still alive, and they had what's called a constitutional convention, which is what it says on the tin. They discussed the Constitution. The definition of Constitution is the law which governs the relations between the state and the people. Okay, a classic example is that let's imagine Germany in the early 30s. Hitler's come to power, and he starts building concentration camps, and people are being killed in concentration camps.
Yeah.
But it was lawful because there was an act of the Reichstag says Actor Right Song. You can have a concentration camp. You can be in garden. If people get killed, it's not a crime.
Great act, eh?
Yeah. In this country, that could never happen because murder is a common law offence. And the coronation oath says that the king or queen will rule according to the laws, the customs, and the statutes agreed on, which means he or she can never give royal assent to an act of parliament which authorises breaching the law and making murder legal.
For example.
But how come we were allowed to give away our country to Brussels?
Well, we weren't. It was never lawful. It was just bluff, and it was got away with. The hidden history of that is that the Crown's principal law officer, and this happened this very week, the Attorney General gave legal advice to the Prime Minister, and she decided to hide it. You're aware, aren't you?
Yes.
Exactly the same thing happened
but
in
1917. It still hasn't been released yet, has it?
I haven't gone online today, so I'm a little bit behind. Lord Kilmuir is
1960.
Yeah, that's right. Gives an opinion to Mr. Heath, and Mr. Heath hides it. Now, unfortunately for Mr. Heath, the advice was put in state papers, and state papers by convention are kept secret for 30 years, but they were released about 10 years ago, and truth researchers have found them and spilled the beans.
It was only revealed in the mainstream media, though, a year ago.
Yeah. Yeah, well, that's right, because the mainstream media are behind, aren't they? And they only reveal stuff when forced. For those of you who read the mainstream media anymore, well, it's a waste of time unless you read the comments pages, because the comments pages are the truth. Generally speaking.
That's why they stop accepting comments on some of these articles.
That's the reason. So what I'm saying is that we've got a document that came about as a revolution in 1688. It's called the Declaration of Rights, and in 1997. There was no public available translation, no copy. It's not a translation because it's in Old English, but the text was not available. So contrast the Americans, it's a revered document, children taught about it, here hidden away. It was actually in the House of Lords library, but nobody had a transcript. And I was doing legal research. I had to keep it low profile because I was a policeman. So a friend of mine by the name of John Bingley, an aggrieved pistol owner, decided to go to the House of Parliament and photograph it. And I've got a document in front of me, which is a book that he wrote at the time. And for those, you see the camera, Declaration of Rights and Bill of Rights are there. He photographed it skin by skin because it's parchments, and he transcribed it. And he also entered into correspondence with the government of the day. And he was able to secure confessions from Mr. Blair refused to answer. He delegated to Mr. Straw that yes, no Prime Minister would encourage Her Majesty to give consent to an Act of Parliament which breached the Declaration, and that's where it stands. In this book, which John Bingley is quite a scholar, has produced, it's got photographs of line by line and the transcript. Now, if that document has been occult, hidden for the last 20 years, why haven't lawyers done something about it?
A massive conspiracy.
Okay, well, the reason is that 20 years ago when I discovered this stuff, myself, John Bingley, and I can't quite remember if John Bingley was with me, certainly a friend of mine, Mike Burke, we consulted Queen's Counsel, a man called Leland Price, then getting on in years, and we write up the result of our researches and submit it to him, and we go and see him in the Temple, the legal quarter in London, and it's like going back 300 years if you've ever been there, he had it was like Hogwarts actually, and he's got half-rimmed glasses, and he finds our document and literally blew the dust off it. And he said, if you're my students, you'd have passed well done. And I was quite gratified because I'm a humble policeman and not a lawyer. And he said, you're quite right. Of course, this has all been hidden, and it's he who told us this vital piece of information. Lawyers have a syllabus to study. It's called the Legal Education Syllabus. And he said, I'm a professor of law at St Anthony's College, Oxford, and I can tell you, you would have passed. I was grateful about that. Anything to do with the Constitution has been excluded from the Legal Education Syllabus. So I'll say that again. Anything to do with the Constitution is excluded from the Legal Education Syllabus, which means a lazy lawyer needn't study it. And because he hasn't asked any exam questions on it, he's not qualified on it either. So you've got a generation of lawyers from that point onwards that know nothing about this, and if they purport to tell you any form of legal advice, they're fraud because they're not qualified. They've never been asked questions. The common law rule is that man may not sit in judgment in his own cause. So if you say to a lawyer, "Are you qualified on the Constitution?" and he tries to say yes, he's telling you lies because nobody's tested him. He's giving his opinion that he's qualified. You see that
so
concept?
they chose not to test them on it specifically, so they wouldn't be. Okay.
Yeah, that's right. Now, a quick way to learn about the Constitution and the revolution that I've talked about is to go to the BBC, probably accidentally. About a year ago, a historian called Lucy Worsley produced a video called "History's Greatest Fibs, Part 2." So if you look at the BBC video online, it's on YouTube. You don't have to go to iPlayer and pay the licence fee. Lucy Worsley explains what's gone on. She explains what happened in the Glorious Revolution. She interviews various people about the Declaration of Rights, and she then goes on to talk to scholars as to what happened, about how it was hidden, and basically say it was Marxist scholars decided to hide the stuff. In the late 1970s. Now, the significance of this declaration is that it's a job specification contract for every Crown servant from that point onwards. There are 13 articles. I've mentioned some of them already. Article 3 says ecclesiastical courts are illegal, and that will ban Sharia courts because it's ecclesiastical, isn't it? It doesn't have to be Christian.
Sharia courts?
Yeah, ecclesiastical courts are...
So they're illegal?
Yes.
Right,
yeah.
and we've got, 85 of them in the country?
Yes, that's right, yeah.
And Theresa May embraces them, presumably?
Yes. Yeah.
I mean, right, okay. So anybody listening out there, this is the state of play in the UK today.
Yeah.
Our politicians are liars.
Criminals.
Sorry, criminals.
Yeah.
Well,
they take an oath of office. The Bill of Rights actually contains the oath of allegiance. I'll just tell you what the history of the Bill of Rights is. The Declaration of Rights is a constitutional settlement obtained at sword point. But that wasn't duress.
Why at sword point?
Because there was a battle in Reading.
Trial by battle.
Trial by battle. The religious concept is whichever side wins, God was clearly on their side. Okay.
We better take back control, then, haven't we?
Exactly. So we've done a talk about lawful rebellion, but that is related to it. If you watch Lucy Worsley's video, what you'll see is that MPs are ignorant of this. I went to saw my one last year. We had a new one, and he had no knowledge. On the video, you'll see, if you picture you've been to Parliament, I dare say, you've been to the central lobby.
Yeah.
You picture the corridor going to the Lords, corridor going to the Commons. The large murals on the corridor going into the Commons, the first one is the Declaration of Rights being read out by the clerk of the House of Lords to William and Mary. So every time an MP enters Parliament, he's passing an image that was intended to teach him about it. And how many know?
Also, supposedly, on the outside of Parliament, there's the Lord's Prayer.
Yes, well, that's right. I'll just tell you the history of what happened to the Declaration of Rights. It couldn't be an Act of Parliament because it was produced by a Constitutional Convention. A Parliament requires Lords, Commons and King to be present. William and Mary are presented with the document and they agree to it. Mary is in line to the throne. William is her husband. In those days, women were property, so she didn't want to rule without him, and he wouldn't let her rule without. So they both got the job. It's the only time we've had a dual monarchy. The next day, and it happens to be the next year, 1689, because the calendar clicked over. The first proper Parliament passes an act. It's called the Crown and Parliament Recognition Act 1689. And what the Crown and Parliament Recognition Act does, it says the deliberations of the Constitutional Convention are to be given the force of an Act of Parliament. So the Bill of Rights is an Act of Parliament, but the wording is what's in the Declaration of Rights. And if you compare the Declaration of Rights, which you'll find very, very hard to do unless you get John Bungley's book, because as I say, it's occult knowledge is hidden, you'll find that the Bill of Rights tells what happened. When you interpret an Act of Parliament, you read the whole thing. You've got the short title, which tells you what it's about. Bill means list of rights. And then it says an Act settling succession to the Crown and declaring the rights and liberties of the subject. And then it says there was a meeting in February 1688, and the people got together as their ancestors had done. And what that is it's a reference to the last time or the previous time this happened, which is 1215 and Magna Carta.
So it is the foundation stone, really, isn't it?
It is, yes, yeah. And
we do. I mean, so basically, we do have a British Constitution. There's just bits and pieces.
Well,
not all in one place.
Well, and now here's the insight. Now, there's a hierarchy of legal textbooks, and you remember, it's as a policeman, I've got access to the Commissioner's Law Library.
The library.
Commissioner's Law Library. There's a hierarchy of textbooks. Top of the food chain is Halsbury's Laws of England. Lord Halsbury was an eminent lawyer, and he set up a publishing camp. So the textbook goes: Magistrates' Court, Stone's Justice's Manual. Crown Courts, Archbold's Criminal Pleading. Higher Courts, Court of Appeal, all the way up to the House of Lords and the Supreme Court. Halsbury's Laws of England. Okay, 34 chapters.
You've read it all?
Not all. There's a chapter on constitutional law, and it begins with this. It says, in the absence of a single codification of our constitution consists of Magna Carta, Act of Settlement, Petition of Right 1620. It goes through a whole list. So when it says in the absence of a single constitutional document, we go back to what went previously. But what John Bingley and I have discovered is that we do have a single constitutional document. It's called the Declaration of Rights. It's something that's been hidden, for whatever reason.
Can I just clarify?
Yeah.
So we do have
a single codified
constitution, which is called
the Declaration of Rights.
Declaration of Rights.
Yes, that's right.
I was talking to somebody in the Libertarian Party, and they didn't believe we had.
Well, Sean Gabb in the Libertarian Party actually started me on this road. I'm a big fan of Sean Gabb, and he wrote a paper about the right to bear arms, and he introduced it to me to the concept of
well, it's for defence, isn't it?
Yeah.
I think that's actually thinking about it. I think with what's coming ahead, I think we do need to be able to defend ourselves.
Well, that's the next topic. We'll talk about that. So we haven't got a codified document. It's no good asking a mainstream lawyer because they're not qualified.
They have been taught.
they may have read about the Constitution, but they're not. They can't give a legal opinion about it because they've never been tested. Because the common law rule is a man may not sit in judgment of his own cause. And we live in the age of internet, and large numbers of people, particularly millennials out there. You need to know this. You need to know this because you remember I talked about two ways to run a country: democracy, where a majority can oppress a minority, or a constitutional monarchy, where the Crown's powers are limited and there are certain things they can't do. They can't suspend the law and have you murdered. They can't tax you excessively. They can't
things you're talking about.
Punish you unreasonably. They can't allow Sharia courts. And I think that's the time has come for this to be made more widely known. I understand John Bingley is coming next week.
He is,
this is a substantial volume. So there's the front page, the declaration and the bill. The declaration is what the convention produced, and the Crown and Parliament Recognition Act 1689 made it an Act of Parliament. And there's the oath. Now the oath is a coronation oath from 1688. And there are three parts in the coronation oath. The first bit is the Archbishop of Canterbury says to the candidate, she asks a series of questions. Now, if you were to go on YouTube and go to Pathé News, Coronation of Queen Elizabeth II, you can see it on video. The first thing that happens is the estates of the realm, the Lords and the Commons, are assembled in Westminster Abbey, and the Queen comes in a plain gown with a huge flowing train with half a dozen 1950s beauties, like yourself.
Thank you.
Sorry.
After the show,
that's right. She's introduced to the four corners of the building, and the Archbishop of Canterbury turns to the audience and he says, "Gentlemen, will you have this lady as your sovereign?" Gentlemen, you have the sovereign. And as the Archbishop was using her word, she curtsies, and that acknowledges that the appointment of a king is an election.
Right.
She's elected, and the gentlemen all say yes, via Queen Elizabeth, and then if you continue to watch the video, you'll find over the next 5 or 10 minutes she's given the regalia of state, which is the orb and the sceptre and that sort of thing, and the sword of justice, and everything that's done there is a contract, and the physical embodiment of the contract that shines is the coronation oath. So the first part of the coronation oath is read out line by line by the Archbishop is, will you rule the kingdom according to its laws and customs? Okay, and what that means is you can't give assent to an Act of Parliament which breaches the laws and customs. So Parliament has no power to abolish itself. Parliament has no power to alter the common law because the Queen promised you wouldn't. The second part of the coronation is, will you exercise mercy in your judgments? And what that refers to is, for example, British policemen, I was taught 40 years ago, discretion. So if you stop a motorist and he's Mr. Respectable and he's got a bit flustered and gone through a red light, it's very unlikely he's going to get a ticket, isn't it? If you stop him and he says something rude about policemen's heritage, he's quite likely to get a ticket.
Right.
And that was coronation. That's the middle part.
Right.
And the third part is the religious bit. The moderator of the Church of Scotland gives the Queen a Bible, and as he does so, he says, "Here's the most valuable thing the earth provides." Because of the knowledge in the Bible, not the gold on the cover. What that does is the Queen is a professional religious person, and she's expected to maintain the Church of England.
Has she read it recently?
Well, there we are.
Anyway, thank you so much for that then, John, because basically the answer to the question is yes, we do have a British Constitution.
Yeah, that's right, yeah.
So thank you, John, and for joining us.
Thank you.
And you.
Thank you very much. It's nice to be here and be educated.
There we are.
And
Yeah, you've got a classroom of 2 here.
Well, I was thinking they were so glamorous, those ladies pushing. It just reminded me of you, Caroline.
it's very much a compliment.
You're going to get
John.
hit later.
Very much a compliment, John.
Oh, what's my defence going to be? You've been so cheeky.
Yeah, because a lady could slap a man and a man couldn't hit a woman. That's where it comes from. A gentleman would never strike a blow.
That's fair enough.
Yeah.
Okay. Well, thank you, John Hurst and Fraser Rees for coming onto the show. And this is part 2 of the constitutional series, and there will be more to come. So thanks to everybody at home for listening, and look forward to seeing you again for part 3. Take care and goodbye for now.